Welcome. Looks like people are just starting to join the room, so glad to have you here. We will plan to start right at noon. As you log in, you want to check around, find the chat feature. That's where we'll do the question and answer later on. Again, if you're just joining, we're going to start at noon, but take your next couple minutes to figure out the chat feature in case you need to ask questions later on. You should see on your screen a slide that says legal risks of social media in hiring. Remember that you are streaming live video for this webinar, so if you have other applications open on your screen, they may interfere with your maximum performance. So free up whatever resources you can on your computer. If you happen to be logging in on a mobile device, you should still be able to get the webinar content, the sound, and the videos, the pictures of the slides. Some of the other features may be more limited if you're on a smartphone, for example. Again, orient yourself with the chat feature. Go ahead and say hello or something like that just to test that out. That's where we're going to do the questions later. I will take questions at the end. If you have questions throughout, please go ahead and enter them as you think of them so you don't forget. But most often I won't answer them until we get to the question and answer period at the end of the presentation, just to keep things going smoothly. Thanks to all of you who are already on. I know we still have a couple minutes. I'm sure some more people will be joining, so I'll give all the formal introduction at that point. Again, your screen should say legal risks of social media in hiring. We'll just give a couple more minutes before I start. Those of you who are already here, there will be slides. The slides will be available at the end. We will do question and answer. Goal is to last about an hour, give or take, depending on the number of questions that we have. I do hope to allow plenty of time for questions. All right, it's 12 o'clock. I'm just going to give a few more seconds for everybody to get logged in and settled on here. Okay, well, it's 12 o'clock. I'm going to go ahead and introduce today's webinar. Thank you for logging in. It is my pleasure to present these webinars on a frequent basis. So if you have any suggestions for future topics, please feel free to contact me to share those, and we will see what we can do to schedule the topics that are most interesting to you into the rotation. Today's topic is the legal risks of social media in hiring. My name is Scott Horton. I am the founder of Horton Law, PLLC, a law firm that focuses on representing employers in labor and employment law matters, primarily throughout New York State, although I have clients, and perhaps some of you are in organizations that are either outside of New York State or that are both within New York State, as well as having employees in other areas, which is fine. Most of what we're talking about with the legal risks of social media and hiring applies across the country based on federal laws or laws that apply at the state level but are similar from state to state. There are some New York State specific aspects of what we will talk about today as well, and you'll know what those are as we are going through. Social media is a topic that I've been speaking about for a long time. The first time I really touched on what could now be considered something like social media was in 2007, a presentation I gave about off-duty conduct, which touched on employee blogging. From there, by 2009, social media in the form of the popular social networks was really starting to take off. And I gave many presentations, wrote articles, and spoke frequently on social media. So at that point in time, it was very new, and everybody was still trying to figure out how this was going to affect workplaces, what regulations could be put in place, what could not. And for several years, I continued speaking about this, and new issues came up. But for the most part, we really weren't seeing too many challenges to what employers were doing, at least in the way of hiring and recruiting and the use of social media in that area. The bigger issues for a while were what employers could or couldn't do as far as regulating employees' social media activity, once they're already employed. And those cases continue, but that's not what we're going to spend our time on today. We're going to really focus on hiring and recruiting, the application and decision-making process related to that. Some of what we talk about will spread beyond just those issues and apply as well to existing employment relationships, perhaps including promotions and the like. Okay, so let me briefly tell you what the presentation is going to cover. But before I do that, just remember that there will be question and answer at the end. You will enter your questions through the chat function, and if you have questions come up throughout my presentation, feel free to just type them in, but I won't get to them until the end in most cases, just so we keep things moving and get through the content. Just a quick disclaimer, since I am a licensed attorney, everything I'm saying here is for general informational purposes. I can't give any specific legal advice to any of you, even if you happen to be my clients through this forum. But that's not going to mean that there's going to be good content here. It just means that there may be something I say that doesn't quite pertain to you because there's something specific about your situation, and I'm just trying to, again, provide a general overview on topics that I think are important for employers. Okay, so the first topic I want to touch on is finding candidates. And by this, I mean using social media or the internet, for example, LinkedIn, to actually identify potential employees in the first place. And I'm going to go ahead and throw up a poll to let you click yes or no as to whether you and your organization look for candidates online. It looks like we have a pretty equal split, 50-50. I don't know if you can see these results, but it's dead split at 50-50 right now on people who do. Oh, somebody just shifted that, so now it's a little bit more in favor. So now we're actually up to about 3/4 of the people online here say yes, their organization looks for candidates online. Okay, we'll do a couple more polls as we go through, and I'll share the information with you just for general knowledge, and so you don't feel like you're the only one in one boat or the other. We'll also be talking about researching applicants, so whether you found them in the first place online or they came in through other, what some might consider more traditional means. We'll talk about some of the issues that come up with respect to then using social media to find out more about the applicants you are considering for positions in your organizations. And then the latter part of our presentation, before we get to the question and answers, we'll talk about keeping track of your applicants. And here I'm really going to focus on some record keeping requirements, some specific requirements, some general requirements, and then some best practice advice in this area. All right, so for starters, let's look at this. We'll consider this a component of your organization's org chart, for example. And here we see we have some blanks or some open positions on the screen. And now we're going to assume that you want to fill those positions and move forward in talking about some of the issues that may arise. Now, since I mentioned the social media is not the Wild West anymore, threw this picture in, maybe in the days long past, if you needed a new sheriff, you had to hop on your horse and go out to the, nearest homestead and see who might fit the bill. Obviously, today we don't have to do that in most cases. Certainly not quite to this extreme. And in some cases, it's almost as easy as going online where there are thousands of people available to work and clicking a few buttons and generating a pool of possible candidates. And if you're really lucky, then you will quickly fill up your blanks on your org chart. And if you we're in a perfect world, you might even do it as demonstrated by the images on the screen here with a whole bunch of diversity on racial and age and gender characteristics. So that would be the ideal, and certainly I think social media can help you do that, but it's not without some obstacles. Because for better or worse, we do have the Facebook police, if you want to call them that. Really, what I mean by this is the various laws and regulations and claims and challenges to practices that many employers have tried that may or may not pass muster now that people are taking issue with them. Obviously, this isn't limited to Facebook, but I use Facebook as this initial example because there have been some relatively recent lawsuits specifically involving some recruiting practices through Facebook that I want to talk to you about. There's a case filed in California in December of last year, so just under 2 months ago now. The case had various parties, which I'll describe, but for our purposes, you can think of it as the CWA versus T-Mobile. I put on the screen, this is actually the first allegation in the complaint, or the first paragraph in the complaint. So I'm not going to read all of this, but basically what this shows is there are a couple of individuals, as well as the Communication Workers of America union, who have filed this lawsuit against a few named employers, as well as a broad class of potential other employers claiming age discrimination through their use of Facebook job advertisements. Let me break all this down. So the named defendants, again, Communication Workers of America. There are a few individual employees as well, but obviously the CWA is the large body with resources to hire top-notch plaintiff side, employee side attorneys to bring this lawsuit. And because it's Communication Workers of America, it makes some sense, I guess. The employers that they did name: T-Mobile, Amazon.com, Cox Communications, Cox Media Group. Presumably these are organizations that Communication Workers of America has some interest in targeting for its various purposes, perhaps including union organizing and the like. But the lawsuit also names, it actually states that it's brought against similarly situated employers and employment agencies, DOEs 1 through 1,000, which they describe as all employers or employment agencies who annually employ at least 2,500 employees, or annually refer for employment at least 2,500 employees, and have purchased or sent employment-related Facebook advertisements that placed an upper age limit on the population of Facebook users that was eligible to receive an advertisement at any time from the earliest date actionable under the limitations period applicable to the given claim until the date of judgment in this action. Now, procedurally, I really don't know how this will work out, whether they'll ever be able to actually go after additional companies through this lawsuit. My guess is there aren't many of you listening to this webinar who are with an organization that has 2,500 employees. But if you do, and you have purchased or sent employment-related Facebook advertisements that place an upper age limit, then I suppose it is possible that this lawsuit would somehow come to bear on your organization, even directly. What is somewhat interesting is that Facebook is not a specific party to this lawsuit, but it seems likely that the ultimate goal, if the case lasts long enough, of the plaintiffs would be to get data from Facebook that would then allow them to identify additional employers. I just want to quickly try another poll. So this poll just asked whether your organization, to your knowledge, advertises jobs on Facebook. Just curious if anybody has actually done that. Not all of you are in a position where you would be in charge of that or know how to handle it. So it looks like we have no one here who knows that their organization has published job ads on Facebook. And that doesn't surprise me. I mean, if there had been one or two that did, then that would have been within the range of what I would have expected. It's probably mostly larger organizations like the ones named and envisioned here that have done that. But certainly others will be trying it because it is a good way to reach people. Okay, so now I wanted to go through some of the specific allegations in this lawsuit so you get an idea of what more specifically they're attacking. It's not just going to be limited to Facebook. I think the theory behind these claims creates some bigger questions given the realities of online recruiting. One allegation states these companies eliminate older workers from receiving job ads by specifically targeting their employment ads to younger workers via Facebook's ad platform. Another is, upon information and belief, nationwide, large and small employers alike apparently believe that it is appropriate and desirable to exclude American workers from job opportunities solely based on their age. We're going to get to this, but I'm assuming that all of you are familiar with age discrimination laws. The Federal Age Discrimination and Employment Act prohibits discrimination in hiring and employment on the basis of age for employees 40 years old or older. In New York, for example, there's no, there is a lower age limit, but it's 18. So age discrimination is prohibited for all adults in New York. Just interestingly, the lawsuit it cites to and discusses the Federal Age Discrimination and Employment Act, but none of the claims are made under that law. They're all made under state laws for probably procedural reasons, but all the laws generally work the same way, that if you discriminate against someone based on their age, then it's not okay. When selecting the population of Facebook users who will receive employment ads, employers and employment agencies routinely focus their ads on prospective applicants who are in age bands that include many workers who are 40 years old or greater. Separate from their allegations here, I've seen statements from recruiting agencies, for example, where they acknowledge that, yes, we have employers come to us all the time that say it would be really great if we could somehow focus our recruiting efforts on a younger population. Comments like, we prefer to get some new blood. We're trying to turn over our workforce. I mean, things like that, all could arguably suggest age discrimination. If you are saying that to your internal or external recruiters, then that could come back to haunt you in a lawsuit, the same way that perhaps some of the practices that these employers used might hurt them. Upon information and belief, Facebook does not stop an employer or employment agency from selecting a younger age range, such as ages 18 to 40, that discriminates against older workers and setting the population that will receive an employment ad via Facebook. So when you do post ads on Facebook, you can choose many characteristics to limit the population of Facebook users that will receive your ads. So age is one of them, but there are other characteristics that you can select as well, geographic location and the like. So it is there as an option within Facebook. These plaintiffs are taking issue with that. Some of the laws at the state level do specifically prohibit aiding and abetting discrimination, including age discrimination in employment. So it is possible that there could be a legal theory against Facebook for enabling this form of discrimination. I'm not going to read all of this, but following off what I just said, Facebook also has some interest group categories that you can use to target your advertising. The ones they identify in this lawsuit are a young and hip crowd, and then the millennial group. So, it is seemingly plausible that if you select to send your job advertisements to people within these categories, that you may be excluding people that are relatively older, above the age of 40, for example. So how does the plaintiff class, CWA, and the individual plaintiffs purport to prove that this discrimination is occurring? Well, they have actually right in the legal complaint itself cut and pasted these exact ads that I'm showing you, because I just cut and pasted them from the complaint they filed in federal court. So on the left, you see T-Mobile careers, become an expert, launch a customer care career, apply now. That's what pops up on your screen on Facebook, or at least if you were in the group that they targeted. And then those three little dots at the top of that ad, if you click on them, one of the things you can select is, why am I seeing this ad? In which case, Facebook will then show you what is on the right here. Most people probably don't click on that, and they don't see, why am I seeing this ad? Maybe they don't care why they're seeing this ad, but for purposes of this lawsuit, there were people who cared why they were seeing these ads. And it says, one reason you're seeing this ad is that T-Mobile Careers wants to reach people interested in customer service based on activities such as liking pages or clicking on ads. Well, they don't attack that. That seems reasonable to target people that like customer service or have customer service skills. But then this pop-up goes down to say there may be other reasons you're seeing this ad, including that T-Mobile Careers wants to reach people ages 18 to 38 who live or were recently in the United States, etc. So Facebook seems to be telling whoever did see this ad that you got this ad because you fit within the identified age range of 18 to 38. Now, I think there are probably many options that T-Mobile could have and may have selected in targeting their ad for Facebook, and customer service and an age range may just have been a couple of them. I clicked on some ads in preparation for this presentation, and Facebook seems to almost always give you an age range. So whatever else it tells you up in that top portion, it seems to give you the age range and the geographic region. I think you could probably identify a bunch of different categories where they put in customer service, and I don't think Facebook is going to give you the full profile of here's everything that the company was looking for, but they do give you this much information. So really not shocking that some applicants who found out about this said, well, that doesn't seem right that I don't get to learn about these opportunities. Interestingly, that even though Facebook itself is not specifically named as an employer, although it obviously fits into that broader category of having 2,500 employees and posting job ads on Facebook, the complaint then specifically includes this Facebook job posting to support its claims. Wonder what it's like to work on the Facebook recruiting team, meet a few of our recruiting leaders, and learn about work culture and opportunities we're hiring. That's what you see on the left. Then if you click, why am I seeing this ad? You will see that Facebook then tells you that Facebook wants to reach people ages 21 to 55. Now on the plus side, at least they're going up to 55 instead of stopping at 38, but still many potential workers above the age of 55 who might complain that they should have received this ad. Now, let me just stop for a second and say this was just filed in federal court in December. At this point, there is nothing even on the docket. There's nothing been filed by any of the defendants in response. So it's very early and too early to guess where this is going. There will almost certainly be motion to try to get rid of this. There may be mediation to try to resolve it. And if there were ever going to be a court decision deciding whether this violated the age discrimination laws, we're probably many months and probably several years away from that happening. But the issue is out there, and there are arguments against it. Facebook has suggested, for example, look, this isn't as bad as they make it out to be. If you wanted to publish an ad in a magazine recruiting people, you could target, essentially different populations by choosing where to put the ad. If you put it in a teen magazine versus a publication geared towards retired individuals, some of the employers who've been taken to task for this kind of respond of, well, maybe yes, we limited our age range, but it's only because based on experience, we know that people outside of that age range, even if they click on the ad, are never interested in applying with us. So we don't want to get charged for them clicking on an ad that isn't going to result in us getting a viable candidate. So certainly plenty of defenses to be had, but it's probably not a good look that somebody can click on your ad and say, oh, you're only hiring people ages 18 to 38, for example. So if you're in that position, whether it be through Facebook or other avenues where you can target very specifically, I'm not sure whether LinkedIn allows you to target based on age or not, but there may be other categories that highly correlate with age, which could also potentially result in claims of age discrimination. Just briefly, in case you think that age is being singled out, there was a year earlier in 2016 a case filed actually against Facebook itself. This case alleged both housing and employment discrimination, claiming discrimination based on race, color, religion, sex, familial status, and national origin. So under the Federal Fair Housing Act and Title VII on the employment side. So this case is a little bit further along, and it is in mediation at this point. So it survived long enough for at least the parties to have to get into a room and try to negotiate some sort of resolution. My really speculative guess at this point is that eventually Facebook will take some effort, either by choice or as a result of a settlement, to avoid allowing people to select who receives their ads, to avoid possible discrimination claims. Now, I think it's likely that you'll still be able to target ads, especially geographically, although even that could have a disparate impact on certain racial categories, for example. So it'll be very interesting to see what these lawsuits end up meaning for online recruiting. But certainly we have very large players in these cases. Just briefly, both Title VII and the ADEA do have specific provisions that address advertising job openings, which say, for example, on the Title VII side, it should be unlawful to print or publish or cause to be print or published any notice or advertisement relating to employment, indicating any preference, limitation, etc., based on race, color, religion, etc., the categories covered by Title VII. And then on the age discrimination side, the ADA similarly says that it's unlawful to print or publish or cause to be printed or published any notice relating to employment. Let's see, where is it? Indicating any preference, limitation, specification, or discrimination based on age. So if you use the examples we just saw on the screen, the employers themselves didn't include an age preference in their ad, obviously, but Facebook filled it in for them in essence. So it'd be interesting to see how that would be interpreted under these provisions of these federal laws. I'm just going to say before we move on to the next topic of sort of screening applicants and candidates that, I would probably think twice before I specifically indicated age brackets for job advertisements online. That data is going to be there, whether it's like Facebook where someone can just click and have it shown to them, or they would have to, get records from the social networking platform. You know, if you got into serious enough litigation, that could be discovered. So try to find other ways to target people who may be right for your job, preferably without identifying age, race, gender types of characteristics. Okay. Now remember, if you have any questions, type them in whenever, but we'll get to them at the end. We're moving along pretty well. We'll have some time for questions. The next group of issues I want to talk about relate to screening your applicants online. I'm going to do a quick poll again. Let's just see how many of you use social media to sort of vet candidates for job positions in your organizations. Looks like we have some fluctuation here, but it's hovering back and forth around about half of you do use social media to review candidates, and then a quarter do not, and then the other quarter say that you don't personally, but other people in your organization do. So if we take that all together, you know, we have roughly 75% of you saying that yes, your organization looks at social media in the hiring process. That doesn't surprise me. I mean, frankly, I suspect unless you're really small and have really tight controls on hiring, that it may actually be closer to 100%. It's just a question of what you actually know is going on and what you consider to be reviewing social media in the hiring process. Not unusual for managers, once they're found out who they're interviewing tomorrow, to, even if it's on their smartphone, type in the name and see what pops up. So, you know, that happens. The number of issues that relate to those practices is actually pretty stark. This is the one aspect of what I'm talking about where if it's an internal review within the organization, there really hasn't been too much by way of specific legal challenge of the practices, but there are a lot of pitfalls if you do it wrong or come up with information that you then use that shouldn't be used. And that's what I want to go over first. So you have all of the discrimination laws. Again, I think most of you are in New York. We have the New York Human Rights Law. If you're in New York City, the New York City Human Rights Law, and then the various federal laws, Title VII, ADEA, as we just talked about, cover many categories. And then the ADA, the Americans with Disabilities Act. Obviously, if you found out through looking at someone's Facebook page that they had a disability and decided not to hire them because of that, that could be a violation of that law as well as state law. So I think you know all of those concerns. The two I want to spend a little bit more time on are the bottom two issues here, the New York Labor Law 201D provisions and GINA, which is the Federal Genetic Information Non-Discrimination Act. And it's surprising to most people how likely it is that the Genetic Information Non-Discrimination Act actually comes to bear on your vetting of job applicants through social media. So we'll spend a couple minutes on that. But first, with respect to, this is 201D of the New York labor law. New York has one of the most extensive protections for off-duty conduct for its workers. It really arose out of the second set of bullets here, the use of consumable products. And what that pertains to most significantly is smoking. In other words, there were advocates for smokers' rights who got this law passed that, among other things, says that you can't discriminate in employment based on the fact that someone smokes cigarettes on their own time. They're smoking other things that are illegal. That's a different question. It's lawful consumable products. So as long as you're of age, smoking cigarettes, chewing tobacco, or drinking alcohol on your own time are generally protected activities, and you can't use them to either not hire someone or to fire them. So especially when social media was in its early days, there were lots of concerns of going on Facebook, for example, and finding pictures of especially recent college graduates with alcohol and drinking and doing crazy things like that. My concern was that if these people were denied employment based on those pictures, then the employer may be in violation of Section 201D of the New York labor law. Fortunately for employers, I haven't really seen those cases come up, but the law is still in the books, and I still think it's possible that, no matter how crazy looking the person's situation is, as long as they're not doing anything illegal, even if they're drinking alcohol, as long as they're of age, then they're protected by this law. Beyond the alcohol and cigarettes, the law protects recreational activities, which specifically, for example, includes watching television. The law is 20 some years old, so it doesn't include social media specifically, but I think if watching television is a recreational activity, then using social media in this day and age could well be deemed a recreational activity. So therefore, even if you said, well, it's not what I see them doing in the picture that I have a problem with, it's the fact that they posted it on social media shows bad judgment. I think there could even perhaps be an argument there that the participating in social media is a recreational activity, so they might gain protection on that basis. The law also protects political activities and union activities. Most of the union activity components would already be protected in the private sector under the National Labor Relations Act, and may be protected in the public sector in New York under the Taylor Law. But this law also covers that. So, for example, you couldn't go online, find out through Facebook that this person organized a union at his previous employer or is an admin for some union's Facebook page, and then decide I'm not going to hire him on that basis. You would violate probably this law as well as the National Labor Relations Act if you're a private employer, and then the Taylor Law if you're a governmental entity. So my concern is you build all of these New York specific off-duty conduct protections in with the employment discrimination protection, and I start to wonder what you're going to find on social media that is a lawful basis for an employment decision. We look at some more laws and it gets even thornier, because the Genetic Information Non-Discrimination Act that I mentioned a few years ago, which has been around almost 10 years now, and still is relatively unknown, on its face prohibits employers from requesting, requiring, or purchasing genetic information with respect to an employee, applicant, or family member of the employee or applicant. It also, of course, prohibits discrimination based on genetic information, but initial interest is the fact that you can't even request it or acquire it, basically, where the regulations go on specifically to say that a request includes conducting an internet search on an individual in a way that is likely to result in a covered entity obtaining genetic information. Again, there haven't been really many challenges under GINA so far. The regulations themselves have been around since 2010, took effect, I think, in 2011. So there's been time for these challenges to be made, but it still hasn't happened. I think the Facebook-related lawsuits that I showed you before show that some serious employee-side attorneys are starting to uncover new ways to pursue employee rights. So I wouldn't be surprised if they get around to thinking of GINA. I'm not sure exactly what it means to conduct an internet search in a way that is likely to result in a covered entity obtaining genetic information. But the important thing to note is that genetic information isn't limited to what you might naturally assume it means. Instead, genetic information basically includes a broad range of family medical history, specifically the family medical history of the employee or applicant's parents, siblings, children, great or great-great-grandparents, great or great-great-grandchildren, great or regular uncles, great or regular aunts, nephews, nieces, first cousins, and first cousins once removed, plus all of those relatives of the employer applicants' family members, which could even include dependents, which could even include stepchildren and adopted children. So genetic information of an applicant could include information that has no genetic relationship to that person personally. It's not certainly uncommon for people to post on social media information about their family members' medical situations, which then becomes genetic information. So is looking at Facebook something that meets the definition of conducting an internet search in a way that is likely to result in a covered entity obtaining genetic information? These GINA regulations from the EEOC back in 2010-11 actually were, as far as I know, the first federal regulations from employment-related agencies to talk about social media, social networking, specifically kind of allowing that if the boss happens to be friends with one of his employees, one of the people that report to him, and he sees through Facebook that that person's mother has cancer, for example, then that doesn't violate GINA in the first instance. The problem or the restriction then comes in that once you have genetic information, even if it's been inadvertently acquired, as an employer, you then have to keep it confidential. So at that point, that boss could not communicate the fact that the employee's family member has cancer without probably risking a GINA violation. So that could also come up, of course, in the applicant context, because you could have managers who are already connected because they're friends or whatever else with people that you're now considering hiring. So if your supervisor comes in and mentions the medical history of family members of candidates that he happens to find out through social media because he knows this person, then you could have some GINA issues. All right, now one other area I want to get to before we get into some record keeping issues and then move on to question and answers is obtaining social media information about job candidates through third parties. Let me put up a poll and ask whether your organizations obtain applicant social media information about applicant social media activity through third parties. So this means, it's not the HR department or it's not the supervisors who are looking up candidates on Google and seeing where it leads, but maybe if you have a third-party recruiter and they're providing candidates along with, sort of a dossier, here's what we found about this person online. Arguably, if they're even providing a copy of a LinkedIn profile, for example, if it's coming from a third party. So nobody's saying yes to this. Some aren't sure. It's certainly plausible that none of you are doing this. But again, especially with third-party recruiters, it might be happening. but it is something that's available. And let me show you how I know that. In 2012, the FTC, the Federal Trade Commission, issued this press release explaining that Spokeo, which is a company that compiles and sells information obtained through the internet about millions of people, will pay $800,000 to settle charges that it marketed the profiles to companies in the human resources, background screening, and recruiting industries without taking steps to protect consumers required under the Fair Credit Reporting Act. This is the first commission case to address the sale of internet and social media data in the employment screening context. I mentioned before, since at least 2009, I was warning people that if you do get this information from third parties, you might have Fair Credit Reporting Act issues. This is the first time, obviously, as it says here, that this actually came to fruition, where the FTC in this case said, no, you can't do this. What they were doing is, saying, well, we compile all this information about people, what people do online, which certainly includes plenty of social media content. We give it to recruiters, people in human resources at companies or whatever, and they do whatever they want to do with it. The Fair Credit Reporting Act says that if a company gets employment-related information about an individual or individuals from a third-party consumer reporting agency, then they have to first disclose to the applicant or employee that the information may be obtained and get their written consent to do it. The same type of consent that you need to run a criminal background check on an individual, the FTC is saying through this case applies if you want to get an internet history or social media background check, if you're getting it through a third party that is in the business of regularly providing this type of information. If you happen to have a son or daughter that's savvy with the internet and you work at HR and you call them up and say, hey, could you run a search and find out some stuff about this guy and send it to me, that's probably not going to trigger the Fair Credit Reporting Act, because your son or daughter is not a consumer reporting agency, most likely, especially if you're not paying them and they're not in the regular business of providing this information. But I think even third-party recruiters who normally provide information about candidates that they're sending over, if they're obtaining information not through the candidate directly, but through other sources, then they may be a consumer reporting agency, in which case you may need the pre-authorization to obtain that. The Fair Credit Reporting Act also says if you then use that information to deny employment, you have to so notify the applicant and give them information about the consumer reporting agency, with the idea that that would then enable them to challenge the information that was provided. So whether you're getting the information from online directly or through some third party, and in addition to all the other information you're getting about job applicants, their resume and application that they submit, interview notes and the like, you could end up with a lot of records, especially if you're hiring a lot of people, have a lot of applicants for positions, and there are some requirements for record keeping with respect to the hiring process. I'm going to throw up a lot of things here, and I'm going to sort of cut to the chase. But first, under various federal employment discrimination laws, the EEOC does have regulations that specifically say that employers have to keep all personnel and employment records, including records dealing with hiring, for at least 1 or 2 years, 1 year for private employers, 2 years for educational institutions and state and local governments. So that's just a regulatory prescription. There's also something called the Uniform Selection Guidelines. These came out in 1978 from a group of federal agencies, including the EEOC. They go into a lot of details about validating employment testing. So if you've ever had to have a validated test, that triggered under the Uniform Selection Guidelines, but it does also apply more broadly. Selection procedures or selection processes under these guidelines include any way of choosing who to hire, including just casual, old-fashioned, informal interviews and review of applications. So these uniform selection guidelines also say that you must maintain and have available for inspection records that impact your selection procedures. So this would certainly include if you do have testing that you do on applicants and any supporting documentation for why that's valid. You have to hold on to that, which would also include the results and the tests themselves. So you'd have to keep records of these. You have heightened requirements. Technically, if you have 100 plus employees, you have fewer than that. You just need to keep the types of records, number of people hired, promoted, and terminated in each job by sex, race, national origin, number of applicants for hire and promotion by sex, where appropriate by race and national origin, and what selection procedures were utilized. Of course, you don't always have all of this demographic information. So that becomes a problem if you're eventually challenged for discriminating in hiring based on these categories. So you can, and some employers have to have methods to try to obtain that information from applicants, obviously not in connection with the hiring decision itself. But to go on to some examples of where you really have to have that information, and you could particularly be taken to task if you don't, federal contractors that have at least 50 employees and a contract with the federal government of at least $50,000, for example, have to have affirmative action plans. Contractors with lower contract values and fewer employees probably still have affirmative action requirements, but they may not be as burdensome. So if you are subject to these affirmative action requirements, then you have to be able to identify applicants and then preserve the records and data about them showing race, ethnicity, sex, veteran, and disability status. And because of the complications related to online applications, there's a specific set of guidelines for internet applicants. These particularly came into play because you might have jobs where through, online job postings, you could get potentially dozens, hundreds, or thousands of applications. And to keep the records that you otherwise have to keep for affirmative action reporting requirements, it could be pretty burdensome. So what they did was kind of try to identify who counts as an applicant through the internet. And you have to meet all of these 4 characteristics to count. So the person has to have submitted their expression of interest through the internet or email. The employer has to have actually considered the person for employment, and they must have possessed the basic qualifications for the position without having withdrawn from consideration before an offer was extended to them. So people who just throw in applications to every job that's open under the sun, whether they meet any qualifications or not, don't count in your pool of applicants that you have to track. This again is just for federal contractors. I'm just throwing it out there in case anyone is a federal contractor. The basic qualifications test involves either what you put in the job posting itself or something that's pre-established by the employer. So if you want to limit your pool of applicants for reporting purposes, if you're a federal contractor, based on their basic qualifications, you need to pre-establish it, and it has to meet these 3 characteristics. It has to be a non-comparative feature. The example the OFCCP gives on its website is that you have to have 3 years of experience in a particular position, It's not a situation where you say you have to be one of the top 5 candidates in years of experience. So you can't artificially limit the number of people that count as applicants. It just has to be anybody who applies that meets the requirement. And then has to be objective. So a bachelor's degree in accounting could be a basic qualification, but you can't say a technical degree from a good school because there's too much ambiguity in what's a technical degree, and it's completely subjective to determine what's a good school. And then it has to be relevant to the performance of the particular position. So you can't just establish some qualification for purposes of reducing your applicant pool, such as, for example, you have to, your first name has to start with a certain letter or a range of letters, because obviously, or as far as I can imagine, that doesn't have anything to do with the ability to perform the job. So that was some of the record-keeping requirements. This is the United States Supreme Court. I could have put any court up here, but here's one that, everybody's theoretically potentially subject to, although almost none of you will ever be involved in a case there, and nor will the organizations you work with. But here's my overall take on it. There's so many different ways that it's possible your organization could get challenged for not having done something right in hiring or employment that I think you're virtually always better off having the record to come back and refute the claims. The only way you're not better off is if the records are bad in the first place or they show that you did something you shouldn't have done. So I'm assuming that the goal would be to have good records in the first place, in which case, why worry about the specifics? Do I have to keep these for a year, 2 years? Is there a state law that has a longer statute of limitations, etc.? I would suggest erring on the side of keeping employment-related records essentially indefinitely, unless and until somebody comes up with a specific good reason why you shouldn't. Fortunately, these days, that no longer means having to have mounds and mounds of papers and physical files. You can usually get away with electronic storage of all this data, which, other than maybe causing somebody to have to scan it in the first place, is generally a very efficient and cost-effective way of retaining information, and it also makes it easy to pull out later if you ever do get a claim. And keep in mind that some of these hiring claims could be that there's an ongoing pattern and practice of discriminating against a certain category over a number of years. So it really is possible that you could be taken to task for a broad time period of hiring practices. With that in mind, we have come just about up to our hour, but I will stay on as long as anybody has any questions to ask. I thank you for hanging on and listening to all this information. Hope it was useful. Just a reminder that if you do ask questions, I'm not giving specific legal advice. I won't have all the details, and it won't be confidential because there are other people who will hear my answers. So give everybody a couple minutes at least to type in any questions that they've come up with. I'll throw in a couple more nuggets for those who are listening. The Spokeo website, if you go to that now, you will find that it has in very clear language that it does not do any employee screening and that it does not provide any information subject to the Fair Credit Reporting Act. So clearly they have tried to address that. Whether they can so easily do so is another question. It's still possible that people are obtaining that information for those purposes through their website and others without complying with the Fair Credit Reporting Act, even though they probably should be taking good measures to prevent that from happening. Again, this is an area where, it's going to continue to evolve just like all other areas of employment law, but I think we are really seeing that there are sophisticated employees and attorneys for employees who are looking to find reason to take employers to task under these employment discrimination laws. And there are plenty of laws out there, as I've gone through, that would give them some basis for doing so. Luckily, I suppose, there are more employment discrimination claims made by people who were actually employees and perhaps lost their job, for example, than there are applicants. Applicants usually just move on, but especially categories of individuals who have a hard time finding employment, older workers, for example, may eventually have no choice but to start scrutinizing hiring processes. I'm going to give another minute. I haven't seen any questions come through. Just going to make sure the chat's going. Perhaps that means I already answered all your questions and then some. But I just thought it was useful to shed a light on some of these issues in a specific way with respect to hiring, so that you have something to think about in some of these areas and can tweak your hiring processes. There's some other best practices that you could work on. If you are going to do screening through social media reviews, then it's ideal to have one or specific group of people in place to do that. So it's not just every manager or every person involved in the hiring process, whatever they happen to find, and they should probably be, whoever is looking at this stuff should really be keeping the records of it. What did you see and what didn't you see? Screenshots and printouts, so that when the person doesn't get the job and goes and changes their Facebook profile to put a bunch of things on there that are legally protected but might discourage some employers, you can come back and say after the fact, well, that wasn't there when I looked. All right, well, I don't see any questions coming through, but I thank you all for spending the hour. And again, let me know if there are other topics that you would like to see discussed. If you have any follow-up for this, then I will be happy to speak to you. And now I'm going to give you the slides. So you should be able to link to them there. You should also get an email probably tomorrow that will also have a link to the slides in them. So give everybody a second to click on that. Thanks again for attending the presentation on legal risks of social media in hiring. I am Scott Horton. My contact information is on the screen if you have any follow-up questions about this or related topics. Thank you and have a nice day.